The Supreme Court is a fortress of quiet authority. But on that Tuesday morning, the silence that fell was something far heavier. It was the sound of a constitutional foundation shifting. Congresswoman Jasmine Crockett stood before the council table. For months, Justice Samuel Alito had dominated the headlines, his controversial public remarks casting a long shadow over the court's neutrality. Now, as Crockett presented her argument in a landmark voting rights case, the air was electric with tension. Then the inevitable, for the third time in just 5 minutes, Alito interrupted her, his voice sharp. "Congresswoman Crockett, that's not what the Constitution says." The entire room froze, every camera, every pen, every breath halted. But Crockett didn't flinch. Slowly, deliberately, she opened the worn, brown leather portfolio that had been resting untouched on the table. Inside was a single, aged document, a piece of history that had been buried, misunderstood, or simply ignored for over a century. What unfolded in the next 30 seconds didn't just silence Justice Alito. It changed American jurisprudence forever, and it all hinged on the words of a long-dead senator. "Stay with us because the truth of the Reconstruction Amendments is about to be revealed." Before this defining exchange, Jasmine Crockett was already known as a legal force. She wasn't just a congresswoman, she was a former public defender, a civil rights attorney, a master strategist with a deep understanding of constitutional law. While serving in the legislative branch, she had intentionally kept her law license active, knowing that one day the fight would require her to stand at the bar of justice herself. This challenge to a restrictive state voter ID law was that day. Meanwhile, Justice Alito had become the symbol of the court's conservative wing, openly questioning the very legitimacy of modern voting rights protections. His partisan-leaning speeches, particularly one given weeks earlier, made his position clear. The Founding Fathers, he argued, would have been baffled by claims that these modern measures were discriminatory. This wasn't just a legal disagreement. It was a fundamental clash of worldviews over the nature of American democracy. Crockett knew she couldn't win this case by arguing policy. She had to beat him at his own game, originalism. She prepared for months, not just refining her arguments, but diving into the legislative records, the messy, handwritten debates of the Reconstruction-era Congress. She was looking for the original, undeniable intent behind the 14th and 15th Amendments. The courtroom overflowed. Journalists, legal scholars, and civil rights leaders, they all sensed a reckoning was coming. And as Crockett stepped to the podium, the whispers confirmed the expectation. Justice Alito, known for his aggressive questioning, was ready to dominate. But Crockett opened not with a technicality, but with a moral clarion call. Crockett script excerpt dramatic reading. "Mr. Chief Justice, and may it please the court," she began, her voice steady. "The right to vote is the cornerstone of every other constitutional protection. When 53,000 eligible citizens were denied their ballots, it was not merely a procedural error, it was a failure of our constitutional promise." The initial exchange quickly turned into a showdown over two conflicting constitutional visions. The state and Justice Alito relied on a strict reading of Article I, Section 4, the idea that state legislatures have the primary, near-absolute power to regulate elections. The text of Article I is quite clear. He insisted, cutting her off. "The Constitution gives state legislatures the primary power to regulate elections. Isn't your real disagreement with the constitutional design itself?" It was the perfect trap, but Crockett calmly stepped around it. "Justice Alito, my position is not in conflict with the Constitution. It is about reading it in full," she replied. Article I cannot be separated from the Reconstruction Amendments, which fundamentally redefined how authority is shared. She masterfully pivoted, using the 14th and 15th Amendments, the Civil War Amendments, as the lens through which all state election power must now be viewed. As Crockett detailed how the voter ID law created unequal burdens on minority voters, Justice Alito interrupted again, his tone now overtly dismissive. "These are mere inconveniences, counsel, not constitutional violations." He thought he had ended the argument, asserting that these choices belonged to the states. He even committed a rare breach of court decorum, pointedly calling her congresswoman instead of counsel, seemingly to diminish her legal standing. But Alito was just waiting for her to step into the trap. The real battle was about to begin, and it all centered on the document she was about to pull from her portfolio. The courtroom tensed. This was the moment. Crockett met Justice Alito's gaze, the air thick with confrontation. The Constitution, Justice Alito, is not only about granting authority, it's about setting boundaries to preserve our most fundamental rights, she said, and since you've raised the issue of constitutional design, let's look at what history actually shows. She pulled the document from the portfolio. It was a copy of the original congressional debates that shaped the 15th Amendment. She had searched the archives for the explicit intent behind the amendments, not the later interpretations, but the raw words of the framers themselves. Holding up the page, she read aloud from a highlighted section concerning Senator Oliver Morton, one of the amendment's key authors. Morton stated the purpose was to place the power of protecting the right to vote in the rightful hands of the federal government, rather than leaving it to the discretion of states that have proven unworthy of that trust. The chamber was silent. This wasn't an obscure essay. This was the legislative intent of the constitutional architects. She turned the page, citing Representative James Garfield, who later became president. Garfield emphasized it was time to establish a principle strong enough to override old state laws that restrict voting rights for reasons unrelated to the act of voting itself. But the final quote was the killing blow. Crockett turned to a section detailing Senator William Stewart, who helped draft the final language. Stewart specifically addressed whether states could impose procedural barriers that nullified the right to vote. He declared, "We are not just creating a ban on racial barriers. We are establishing a positive principle that the right to vote must be genuinely available to all citizens, regardless of their background or position." This wasn't a ban on discrimination. It was an affirmative federal mandate to ensure access. These words, read aloud in the highest court, directly refuted Alito's core argument that the amendments only banned explicit race discrimination. They established a far broader, more protective purpose. Crockett drove the point home with surgical precision. These are not mere historical details, Justice Alito, they are the official explanations of constitutional meaning given by the very lawmakers who wrote and ratified the amendments. She stated. She paused, then delivered the unforgettable summation. To interpret Article I today as though those amendments never existed is not textualism or originalism. It's selective constitutionalism. The phrase selective constitutionalism is hung in the air. Chief Justice John Roberts, recognizing the gravity of the shift, took the extremely rare step of extending Crockett's time by 5 minutes. She concluded by connecting the historical principle back to the case evidence. The state's law imposed exactly the kind of procedural barriers the framers sought to prevent. The framers of the 15th Amendment would immediately recognize what is unfolding in Jefferson County today. She declared in her closing line, "The real question before this court is whether we possess the same constitutional courage to see it as they did." 3 months later, the court announced its decision. The result was a stunning 6-3 majority opinion, written by Chief Justice John Roberts. The court struck down the contested voter ID law and established a groundbreaking new standard. Roberts wrote that when voting laws produce measurable disparities in access, courts must apply heightened scrutiny. This rule, he emphasized, flowed directly from the original understanding of the Reconstruction Amendments that Crockett had unveiled. The case was over, but the story was far from finished, because the most stunning twist didn't come from the majority opinion. It came from Justice Alito himself, the man who had fought her every step of the way, who had insisted her argument was flawed, authored a concurring opinion. While he maintained his belief in state discretion, he explicitly conceded that the Reconstruction debates, illuminated in this case more fully than ever before, established real constitutional limits. Why did the man who had fought every step of the way write a concurring opinion? The reason changes everything you think you know about the Supreme Court. Crockett didn't just win the case. She forced the philosophical change that mattered most. The impact of the Crockett brief rippled far beyond the court's verdict. Legal analysts across the political spectrum acknowledged a constitutional reckoning. Professor Akilama of Yale Law School said Crockett used originalist reasoning to prove that the true understanding of the amendments offered far stronger protections for voting rights than modern courts had recognized. It was a masterclass, and the changes weren't just academic. 2 months after the hearing, the Supreme Court unveiled the first binding code of conduct in its history. The timing was undeniable. Crockett's demonstration of how a justice's public statements could erode judicial impartiality was the final push needed for these long-overdue ethics reforms. The Crockett method, the process of using forgotten historical records to redefine constitutional meaning, became a model for civil rights litigation nationwide. The challenge he issued to the nation was simple. This was never about partisan gain. It's about ensuring that our Constitution fulfills its highest purpose, protecting the fundamental rights of every citizen, especially the right that safeguards all others, the right to vote. What began as a tense confrontation grew into a national reminder. The Constitution is not a frozen document from 1787. It is a living framework that includes the transformative Civil War amendments, written by a later generation determined to make democracy more inclusive. Congresswoman Jasmine Crockett had not merely won a legal argument. She had reclaimed a constitutional vision that had been forgotten for too long. And her challenge echoes in every courtroom, every classroom, and every ballot box today. Do we have the constitutional courage to see it as clearly as they did?